Yes, Mr.
My lords, my lady. Can I start by making some opening remarks? And the first one I must mention is there's been a significant change of legal personnel in this case that your lordships
So we can see.
you can see for yourselves. So I won't spend long on this. First of all, I appear for the first time in a court on behalf of the Astor defendants, leading Mr. Daniel Koo, who hasn't been in this matter before. We are instructed by DWF, and DWF have been the Astor defendants solicitors the whole way through. My learned friends, Mr. Cloherty, King's Counsel, Mr. Abraham and Miss Wilkins appear today in all but Mr. Abraham's case for the first time. They are instructed now by LK Law. LK Law is the third law firm to be on the record for the claimants. And Mr. Abraham is not on the recent pleading, but he was in the original counsel team that were instructed by Paul Weiss back in the 2nd of August and following. As an introductory remark about this case and what this case involves, my lord, we say that the claimants have committed very serious and entirely deliberate material non-disclosure going to the very heart of the cross-undertaking. We say in particular, two critical aspects of the cross-undertaking are directly in play and were. First, whether they have or had the means to pay up compensation promptly, should the court so order. And secondly, and perhaps unusually, whether they would comply or not. This court and the courts in general are, of course, extremely familiar with material non-disclosure and see a great many cases of that nature. But we submit that this is a really quite remarkable instance whereby the claimants put only a single line assertion about the wealth of Mr. Salinas, nothing about the second claimant, RBS, the actual contracting party, before the court at the without notice stage. In an otherwise array of material in vacation on a remote hearing. So your lordship should know, and I will take you if I have time.
Sorry, does the wealth of RBS matter if Mr. Salinas had the relevant wealth and willingness?
Well, my lord, no, I fully accept that. But there are two claimants and they both had the opportunity to say so. What you will see as an emerging picture, and particularly when it comes to the pleading, is that for the first time, RBS and its wealth is declared. So there's complete radio silence when it comes to it to start with. And then when it comes to the reply and the defence counterclaim, suddenly, and I believe for the first time, it's declared that RBS has wealth. And it's in fact pleaded first. And in fact, it's pleaded that both RBS and and Mr. Salinas together have the right amount of money in order to be able to cater for any of the counterclaims that might arise. So that is a new introduction. The point is that the ex parte applications, plural, of which there were three, that simply didn't feature. And the blizzard of material that your lordship should know about, and I'll just briefly show you, if I may, the skeleton argument in due course that was put before Mr. Justice Jacobs on the 2nd of August during vacation, was 52 pages long. I haven't counted the authorities, but maybe 36, something like that, authorities. It accompanied a 35-page affidavit from Mr. Salcida, as I refer to him. It appears that that was unsworn, certainly unsigned, because when we actually see the first version of it, it appears to be on the 5th of August. So that appears to be 3 days afterwards. And it was accompanying a 760-page exhibit list. And the time estimate for the pre-reading was given as 1 hour. We don't know exactly how long the hearing lasted. The transcript runs to 19 pages. And we have estimated, I hope fairly, that it's about 40 minutes worth of time before the learned judge. And he was given a 2-hour estimate of the potential time of the hearing, but it only lasted, as I say, about 40 minutes. But anyway, so in those circumstances, we say that was wholly incomplete. there was, at the without notice stage or stages, sequentially, because there were three of them, no evidence whatsoever about Mr. Salinas' net asset position. No evidence about the location of any assets, although it pretty much appears certain that there were none in the UK. No mention whatsoever of the, without being hyperbolic, gigantic tax liabilities associated with Mr. Salinas and his conglomerate. No mention that Mr. Salinas is a man who goes to great lengths not to pay his debts or a respecter of judicial judgments and involved in evasion of judicial pronouncements, orders, and ultimately removal of assets from a receiver's grasp in order to be able to defeat justice. And there was no mention, as I've already said, about the RBS position until later, as I've just made certain.
You're obviously going to come to this, but in relation to that latter point, about evasion of judicial pronouncements, removal of assets, is, apart from the material that's in the unagreed bundle, which I have in mind, is there anything else in the material you rely on which demonstrates that? No, there's one other document which relates to, which refers to a history of debt evasion. There is also the US bondholders action. What is quite interesting is that there is a paragraph whereby all the complaints were summed up, which would have been before Mr. Justice Calver. I'll call that paragraph 76. I'll give you a page reference to it in a minute. But paragraph 76, A to M, I think, is the list of material non-disclosures. When you compare that with Mr. Salcida, who answers it in, I think, his fourth affidavit, he trots through the same. No, but forgive me, I just want to go, because of course you very fairly pointed out there's a difference between inability to pay and unwillingness to pay. Indeed. If there is an ability. Indeed. And we may not be looking at the same things for those two. And in terms of the evidence you say supports an unwillingness to pay, there's the material that the judge didn't take into account, which came at the last minute, which we'll come to. And what else do you say? Well, the US bondholders action. And there is passing reference, I can't recall the document off the top of my head, but we will hopefully come to it, to a general trend of not paying judgments. But squarely, my best material is the AT&T litigation in the New York court.
Can you just tell me the procedural position as far as that is concerned? I mean, obviously we're aware that there's an unagreed bundle. But my present understanding, which may be faulty, is the judge did not admit the material because it was too late. So therefore it wasn't before the judge. I don't understand there is any appeal against his decision not to admit the evidence. If I'm wrong about that, you'll correct me. Nor do I understand that there is any formal application to this court to adduce further evidence. And therefore, I'm scratching my head as to the basis upon which you invite us to look at the unagreed bundle, leaving aside the fact that it's an unagreed bundle.
Certainly, my Lord, and thank you for raising those points. The first thing is, I don't think that Mr. Justice Calver ruled out the argument in respect of it.
He didn't admit the documents, did he?
Well, my Lord, I think he did admit the document, well, in the sense that he listened, and I can show you the transcript references, to my predecessor, Mr. Bayard, King's Counsel, who addressed him on these documents. And you can see, when I take you to them, that there was an interplay between the learned judge and Mr. Bayard, and he says, yes, I mean, I can take you straight to it if you like. It's supplemental bundle, tab 16. Sorry. Thank you. My Lord, I'm grateful. So if we find tab 16, and at bottom right-hand corner, the larger pagination, 131, and this takes into Mr. Bayard's submissions, and you can see the standard way that the pages are laid out. And at page 69, so bottom left-hand side, then he moves on at line 15 to 2 further points. Mr. Salceda has had a very checkered career, and then he talks in line 22 about some other event which led to a resolution by sort of plea bargain to $7.5 million fine, which I'll show you that material. Then over the page to page 70 internally. Secondly, I turn to material which my lord may have received, I hope you did, overnight, the information that we have now received from the New York court. I don't know in what place your lordship may have it. And Mr. Justice Calver says, these are documents I was sent this morning. I think it was sent yesterday, but it may have been sent to you by your clerk this morning. I have 4 attachments to an email, and then there's a description of it. And the last sentence at line 15, I do not know which order that will be, but can I invite your lordship to find that? And he says that the August decision, yes. Can we go straight to Judge Maisley's ruling? That's the New York judge. If you wouldn't mind, please. Yes. And then there's commentary. So, my lord, far from it, there was then a long passage whereby the material that was then available was put before the court. The court interacted with it, and at no point during the actual hearing was it stopped. And this is actually the last point that Mr. Bayard had raised, because you can see on page 132, big 132, and then you can see on internal page 75, that Mr. Bayard wraps up just a few moments before lunchtime, and there's an interplay about whether Mr. Robbins wants to start then or after the short adjournment. So there is a long passage whereby all the relevant points are made, and so it's omitted. So that's.
Well, did Mr. Robbins then object to that?
Yes, I think he
must
have objected to that. We don't have the whole of the transcript, and obviously.
What did the judge say about it?
I'm not sure if we've got. Well, can I just check whether or not it's actually right? I've jumped to the assumption that he has. That there was objection by Mr. Robbins, but I certainly accept that the judge decides that it's, as it were, all too late when it comes to the judgment. But can I just check that while that's...
Whilst that's being checked, can you just point me to the passage in the judgment where he says it's too late?
Well, he doesn't, actually. I think it falls under the rubric of it's all highly contentious, but I don't think that there
my understanding
any specific...
this material is not mentioned in the judgment because it was objected to on the grounds that it was too late.
Can we just check that with your lordship? I don't want to mislead the court in any way, shape or form, either in my favour or indeed against my client's interests. So can I just very carefully check that and come back to your lordship? I've got more to say to your lordship on it than that. It seems to me that
I'm sorry, this is deeply unsatisfactory. There is material that you're relying on, and you're not able to tell us whether the judge admitted the material or excluded it. And, of course, unless he had admitted it, then, and it would be quite surprising if he had, given how late it came in, unless the judge admitted it, how can we look at it when you have no application to adduce further evidence?
Well, my lord, in any event, I apologise if it appears to be unsatisfactory, and I'll do my best to correct any failings on our part. But in any event, my lord, it has to be surely of relevance when it comes to the questions which are left rather lightly at the end of Malone and Friend's skeleton arguments about the idea that the court might intervene by either contemplating a regrant of the order or contemplating a form of order on terms. And this must be relevant material at that time. So that really bifurcates into 2 points. One is that it's all well them saying, and there's a very large section of their skeleton argument that says there's a sort of fair principle of justice, which is proper notice, and a lot of authority put forward for a very standard principle about proper notice. But at the end of the day, that was on the 19th of September, and we're now 9 months, 10 months further down the road than that. And if there is any contemplation that they clearly do have in mind, that they're going to invite this court as an alternative remedy to actually looking at whether or not they are in a position now to persuade the court to do a regrant or to issue an injunction or continue an injunction on slightly different terms, then that simply has to become relevant.
But they don't need to answer evidence which isn't in the case.
No. And if it was adduced too late before the judge, and he excluded it because it was unfair, because there wasn't an opportunity to deal with it, then it wasn't evidence which he could take into account, either for the purposes of deciding whether there'd been a non-disclosure, or if there had, whether the injunction should be continued. Yeah, and equally, on an appeal, those two aspects, if we have to consider them for ourselves, can only be decided on the basis of the evidence which was properly admitted by the judge.
Yes,
so it's important, isn't it, for us to know
it is important, my
Lord. Whether he did admit the evidence.
It is, my Lord, and I will try and rectify that as quickly as I possibly can. It appears that there's no, contrary to what my assumption was, there's no actual exclusion of the evidence, but I need to give that precisely, so I will make sure that we do know that. And I apologise again if it's not clear to your Lordships.
But you need to demonstrate that he admitted it, because it was plainly very, very late. And so you need to demonstrate either that he positively admitted it or that it was not objected to.
Yes. Well, what I can tell you, Lordship, is your Lordship's got the timeline, which is that there were these very large freezing orders and proprietary orders that were made between the 2nd and the 7th of August. And then the hearing of the effective return date of the discharge application was the 20th of September. And there's a huge amount of material to be dealt with. And the simple point, and I'm told that the judge was informed of this, but it's not within the selected transcripts that we have before the court. The judge was informed as to the reasons why it was late. So there wasn't any embargo on using the material at that point in time. The judge was informed, and you can see the passages for yourself, that there was then submission in respect of it. And it goes to, of course, 2 points. One is, as well, the misbehaviour that is identified within that material. But secondly, which is the non-admission, the omission of raising the material in the first place, which, of course, we very much pray and aid. So we're saying that it's not a question of simply, here is non-disclosure, look at these points, and these points speak for themselves. The major point is that this material was known to these people, and these are including Mr. Salinas, who is personally criticised, found to be inferred to be an alter ego defendant, is joined to the proceedings, findings that he has actually personally orchestrated the removal of the assets in question to defeat AT&T within 3 days by getting himself authorised to actually act on behalf of the company, far removed from him in his overall empire. So this is key material for what was omitted to have been informed in the court. So that's sort of procedural aspect number one. I've put before you the idea that if they vaguely hope to be able to persuade you to hang on to the remnants of this, if your Lordship was with me in any other regard, then they have to deal with this, because they can't simply spend 2 pages of a skeleton argument saying there was no notice back on the 19th of September, 20th of September, and then not simply deal with it. They have to deal with it at some point. And one of the remarks...
I have a difficulty with that.
Sorry.
If you're going to... Yeah. If it's the case that the judge excluded the evidence because it was too late...
Of course.
...then it isn't incumbent upon them on an appeal to adduce evidence to meet it.
No. Well, my Lord, in respect of the appeal, your Lordship's right, but I'm just trying to persuade your Lordships and my lady that there would, I think, be a very different position if in this whole sphere one's looking at the overall position with regard to a potential continuation of the injunction or a regrant, which is very much a live matter and put as a live matter by my learned friends. So in those circumstances, that is something which brings it back into play. They can't just simply duck it 9 months later.
Well, if we reach that stage,
yes,
and we were to accede to an invitation that we should do that rather than remit it to the judge.
Yes.
Speaking entirely for myself, it seems to me that we should do so, if we were to go down that line, on the basis of the evidence which was admitted before the judge. If, on the other hand, it were going to be remitted to the judge, then you might be in a position to say they would have a further opportunity to deal with it and might be expected to do so before that decision were taken. Is that a fair way?
That's very fair. May I take a further point against myself, and I don't want to make a habit of doing it, particularly if I get it wrong. But can I also say that I agree wholeheartedly with Lord Justice Arnold when he says that, well, and if you wanted to object about that course, then that should have been a discrete ground of appeal. And I accept that that is the case, or rather I accept that it isn't the case, that there was a discrete ground of appeal. I didn't draft the grounds of appeal. They're signed off by others. But nonetheless, we are where we are. Nonetheless, I accept your Lordship's introduction of that aspect of it. Can I try and now correct any lack of clarity that I may have introduced, for which I've apologised? The position I'm instructed is that it was not specifically objected to by Mr. Robbins. It was not relied upon or mentioned by the judge unless you read his judgment at paragraph 121 as somehow incorporating that. And that's what I said to you earlier. That's at page 142. I've taken the judgment out because it's sometimes easier to do it that way. But paragraph 121, he says, and I'll read it out, once again, this is all highly contentious. See Mr. Salceda's fourth witness statement, and the court cannot and will not embark upon a trial within a trial to establish whether or not facts existed which are alleged to be material.
Well, you can't there have been referring
well, I don't think so.
to this material, because that obviously wasn't dealt with in Mr. Salceda's fourth witness statement.
No.
So that seems to proceed on the premise that the relevant evidence which he has admitted as having to be taken into account was that which had been adduced before Mr. Salceda's fourth witness statement. It doesn't include the new material.
Correct.
And to that extent proceeds on the assumption that he was not treating it as admitted, doesn't it?
Correct, my lord. Yeah. I mean, the position that's been taken in the skeleton argument is a notice point that doesn't seem to have been taken before, although we don't know whether that was mentioned in closing submissions. We'll find that out as well. The one last paragraph of their skeleton argument simply takes the identity point, which is there was no link to the identity of the parties before her honour judge, the lady judge in New York. What? Maskell, thank you. So, my lord, can I hope I've dealt with that question.
I took you out.
No, not at all. That's the nature of it. So that's absolutely fine. And I'm sorry if I made it heavy weather, but hopefully we've got there in the end. So where I'd got to is I wanted just to say a few general points, give you the structure of how I'd like the rest of my submissions to go, and hopefully fit into the timing that we have available. So the statement of the obvious is that the cross undertaking and the making good of it by evidence is a fundamental part of any injunctive relief. It is the price of entry and a condition for being permitted to make a without notice application. It is especially important where the injunctions are of the nuclear variety, such as a freezing order, a proprietary injunction, or an Anton Pillar order. That was not offered here. So none of the material was made.
Sorry, what wasn't offered?
The evidence to make good the cross undertaking. So none of the material was put in front of Mr. Justice Jacobs. who must have assumed, as would be standard, that the evidence was present that the claimants were good for the cross-undertaking. Specifically, the first claimant, Mr. Salinas, was good for the cross-undertaking, and that's the standard position. Mr. Justice Calver, we say, failed to respond to the clear positions presented to him of the failings of disclosure, and this court should intervene. So the structure I should like to just adopt, and I'll try and move as quickly as I can within my own structure, and then leaving time for answering questions from your lordships and my lady, breaks into 5 sections. The first is legal principles and practice, and I'm of course very well aware that this court will be extremely familiar with these principles. Secondly, what went wrong in this case. Thirdly, what the claimants should have explained. Fourthly, where the judge went wrong. And fifthly, what to do next about it. So the legal principles, if I may just start with principles, and then I will invite your lordship to look at 1 or 2 authorities, either by referencing to them, and your lordships look at them in due course, or me very quickly taking you to 2 or 3. The legal principles, I would hope, are uncontroversial propositions in the following regard. First, a claimant who seeks an injunction or without notice relief owes a duty of fair presentation at the without notice stage. Second, that duty extends to all matters which are material. Thirdly, it's common ground that a claimant or an applicant's ability to meet the cross-undertaking is always a material factor, and that much is expressly conceded at paragraph 50 of my learned friend's skeleton argument. Just to expand upon that, fair presentation means that the applicant, via legal team and via the evidence compiled by the applicant, must make sure that the full story is before the court. In doing that, an applicant must therefore act with scrupulous fairness in its presentation. There is one authority which I have seen in my preparation of this case, which I'm afraid to say neither of us, my learned friend or my learned general, I can find at the moment, but there's a reference to as if presenting the case on behalf of the absent respondent. And I'll see if by the end of today's play we can find that reference for your lordships and my lady. So an applicant must act with scrupulous fairness in its presentation, and in doing so has a duty to act with utmost good faith. It's what Sir Nicholas Brown Wilkinson, then the Vice-Chancellor, described in the case called Tate Access, which is at your authorities bundle 10 at page 150, as the golden rule. The duty has often been described as strict, akin to the duty of an insurer. At the back of the authorities bundle, both parties have put in some extracts from G's helpful book on commercial injunctions at 901 to 03, and I'll try and summarise those, but they're to be found there, and they're heavily footnoted with reference to a lot of the cases that before your lordships. The first is, any applicant to the court for relief notice must act fairly in all material respects, and preparing and presenting the application, and afterwards, in connection with it and the ex parte order obtained.
Should we turn these up?
Yes, of course. Not exactly.
They may not be at all.
Trying to do a sort of working summary.
It's easier for our note.
Of course. So it's the authorities bundle, and it is tab 29. So chapter 9, so maybe I'll just read out, as it were, my highlighted parts. Of course, there are other parts. So at 901, any applicant to the court for relief without notice must act fairly in all material respects in preparing and presenting the application, and afterwards in connection with it and the ex parte order obtained. This includes a duty to act in the utmost good faith and to disclose to the court all matters which are material to be taken into account by the court in deciding whether or not to grant relief without notice, and if so, on what terms. This is a general principle which applies to all applications for relief to be granted on an application made without notice or on short notice. Once breach is established, it will normally be irrelevant to investigate where culpability lies between the claimant and his legal team, or to distinguish between the advocate's own responsibility to the court and the collective responsibility of the claimant and his team. The policy of enforcing scrupulous fairness should not be diluted or undermined by allowing a client to blame his legal team. Then I'll skip 2 paragraphs because there's a discussion about those points, which doesn't arise here. Then picking up at the 3rd paragraph, it says, it applies not just to disclosure of facts, but to absolutely anything which the judge should consider. It's part of the duty of an applicant for without notice relief to present the application fairly. And I think we can leave it there. Over the page to page 291, so we're in 9002 now, picking it up halfway through. This rule applies with special force to applications for Moravian or Anton Pillar relief, which by their nature are particularly liable to cause substantial prejudice to a defendant or other parties. I'm going to take you to Bank Mellet, if you have time, where this quotation is lifted, one of the few actually in this whole section. The rule requiring full disclosure seems to me to be one of the most fundamental importance, particularly in the context of the draconian remedy of the Moravian injunction. It is in effect, together with the Anton Pillar order, one of the laws to nuclear weapons. If access to such a weapon is obtained without the fullest and frankest disclosure, I have no doubt at all that it should be revoked. And he continues, the duty continues after the ex parte application and includes a duty to return to court with new developments until proceedings have reached a stage where the defendant is in a position to make his own application to discharge or vary the injunction, which normally will be once there has been service of the claim form, order and supporting documents, etc. And then if I can pick it up over the page at 9003 material.
So just pausing there,
yes,
does that mean that the right amount, if one's looking at what the amount is that matters, is the potential liability on a cross undertaking for damage caused in the period between the grant of the order without notice and the point at which the defendant will have had an opportunity to get back before the court to seek fortification or discharge?
I think in principle, yes. Of course, that could be from 0 to 100%, because every set of circumstances could give rise to a completely different range of events that can happen during the exposed period of time.
Right, but that's the exposed period that one's looking at.
Yeah.
One's trying to work out how much are we talking about?
Yeah. So, could I add a matter of practice for your Lordship's considerations? In reality, we all know that there is a very significant first mover advantage in being able to get an order, and an order on particular terms. It's very difficult in practice to dislodge that. So I would ask your Lordships to, and my lady, to contemplate that in practice, it's not a sort of a 100-meter race from the beginning. It is difficult in practice to remove something that has been in place for a period of time without there being a significant shift. So I think the ultimate litmus test becomes a bit different or more difficult to impose. How one expresses that as a matter of principle, I would struggle to help your Lordship with.
I wonder, because it's not just a question of an opportunity to discharge, but it's an opportunity to apply for fortification if there's been no fortification.
Yeah.
And when an ex parte order is made, then the court and the claimant, to some extent, are speculating about whether there is any exposure as a result of losses caused by the order, and if so, what it might be. And the information on that is primarily in the defendant's hands. It's not to say that the court can't make an intelligent guesstimate based on the nature of the assets, the nature of the defendant's business, and so on, and it will need to do that if it's going to protect the defendant for that period until the defendant can come along and say, these are what I would want to do with these assets, this is why I'm exposed to losses, these are the kind of level of losses I'm likely to be exposed to, please will you order fortification on the cross undertaking to the amount of X? So that if that's the right way of looking at it, it is the exposure period before the defendant has had the opportunity to do that, rather than discharge the injunction, or the two may go hand in hand if there's no fortification.
I'm grateful for your lordship putting it like that. There is unquestionably some potential interplay. And I say potential because one of the points I want to make to this court and the court to accept is that there is a fundamental difference between the cross undertaking and what that duty, which was wholly omitted, involves, and fortification, which is a different matter. Fortification can arise in different contexts, in different circumstances, where there's been wholly adequate disclosure. It addresses different matters, or it can address different matters. We take the view that there is a fundamental difference in principle, and this is one of the reasons where Mr Justice Calver did, I'm afraid, lapse in his analysis in the relevant part, is that it's not simply a trade-off for fortification. So I'll develop that a little bit later at the right time. I know we're talking about it now, but can I just say that's coming? Just think about, if I can ask you to do so, how the injunction goes. The ex parte without notice application goes ahead. And your price of entry to the cinema is, can you give a cross undertaking, which is a good and safe cross undertaking for the court to accept? And that requires two things. The less usual one is whether or not you really mean it and that you will comply. That's engaged here. The first and more usual one is that you can comply because you've got adequate means to do so. And one can think of all those missing trader MTIC injunctions that one used to do in the Chancery Division, whereby there were nil asset companies that had been stripped of money, and a liquidator, insolvency petitioner, was acting on behalf of the claimants in seeking those orders. Very often there would be a Schedule C. HMRC itself would put the matter together, would give an unlimited cross undertaking, and there would be evidence in respect of all of that, and that would be before the court. That's typical practice area. So when you go in as an applicant, you're seeking your almighty order, as in this case. You have got to preempt all that. You've got to show that you've got the price of entry to the cinema. You've got to show that you've got the money in your pocket. You've got to show that you're prepared to take the money out of your pocket if you reluctantly...
We're on the question of what do you mean by adequate means?
Yeah.
And to answer that question, you have to make an estimate of what means are necessary
and I'm not disagreeing
in order to meet an order on the cross undertaking, and that was the point I was on.
Well, but I think that there's a trifurcated position whereby the court does its best at relevant times to assess what the amount of a fortification might be. Yes. And it can do that prior to anything coming in from the respondents.
Yes.
Of course, it can and does do that from time to time. But keep in mind at all times that that is not the same thing as whether or not the person should be admitted to the cinema in the first place, because they can show that they have the means and that they are fairly going to apply those means and not going to resist in giving the cross undertaking. So the cross undertaking is this solemn promise that is completely separate and discrete from questions which are more of detail, which is about fortification.
Well, I'm sorry to take you out of your course, but
not
I can understand that. The cross undertaking was given in this case in an unlimited amount.
It was.
So what we're concerned with is whether there was any material non-disclosure, to use the old-fashioned term, unfair presentation, in relation to an ability to meet the cross undertaking if and when it was called on.
Absolutely.
And that's a question of, leave aside willingness, that's a question of adequate means, and that engages the question, adequate for what kind of losses? So, and that's exactly the question that is asked when you're asking the question, should the cross undertaking be fortified, isn't it? It's the same question.
Well, but I think they're related questions, but it doesn't follow automatically that the court should ask its first question of, shall we go immediately to looking at fortification? Because we need to know whether or not, realistically, the price participation is a price that is in the pocket of the claimants, because you might, as a judge, simply not accept that you're being given a proper cross-undertaking. So that's the stage at which I'm trying to capture everybody's imagination, is that what it shows is that for two different reasons. One, because there was no evidence at all. There wasn't evidence which we're just criticising. There wasn't any evidence whatsoever. There was
just not quite right, is it? There was evidence that he was a very wealthy individual worth billions. You're perfectly entitled to say
there was an assertion.
There was no detail. Well, that was evidence. That was evidence.
Okay, well,
you're perfectly entitled to say there was no detail about that. There was no revelation of underlying material, and so on. But I think to say there was no evidence is putting it too high.
Well, I don't know, my lord. I mean, I don't want to be accused of being the batsman that doesn't walk. So I hear what your lordship says completely. I would just point out there was an unsworn affidavit that was put before the court. So there was one skeleton argument of 52 pages length, and there was one unsworn affidavit and 760 pages of exhibits.
Was the judge told that it was going to be affirmed in those terms?
I don't want to jump to what I know and what I don't know.
In urgent cases.
Of course it does, my lord. I mean, I'm not trying to sort of draw artificial distinctions. Of course, I have no doubt that the judge was left firmly in the mind of what did happen, which was that without any changes that I can bring to your lordship's attention, that affidavit was signed off. So I suppose your lordship could say it's as good as signed off. I accept that that's the case. And when we have a look at the material, it is the case that there is an assertion as a witness. Not, it should be said, Mr. Salinas, and we've never heard why Mr. Salinas, who's giving the undertaking, couldn't actually get around to giving his own undertaking from his own witness statement if it's all going to boil down to an assertion. So it is a third party, albeit a senior employee within the empire, who is giving an assertion without any detail or any secondary level of evidence. That's what it amounted to, my lord. If I could just return, I'd like to get through to this material of the legal principles, but which are critical, because then we can actually compare and contrast. Then we get down to the material itself. So I would just finish off at 9.03, which is materiality. The applicant is permitted to apply without notice only on the basis that he has complied with this duty, which has been described as being governed by the same principles which require an applicant for insurance to act in the utmost degree of good faith. And of course, what we know that means is full declaration. The duty extends to placing before the court all matters which are relevant to the court's assessment of the application. And it is no answer to a complaint of non-disclosure that if the relevant matters had been placed before the court, the decision would have been the same. The test as to materiality is an objective one, that this is common between the parties, and it is not for the applicant or his advisors to decide the question. And I think for the moment, that's all that I need to show you, your lordships and my lady. I wanted just to show you, as read the authorities bundle, Bank Mellet. I'll take these things quickly because there's a lot of authorities. It should be said that when one actually looks at what the material was before Mr Justice Calver, it was very much pared down. We've got an extract of the argument, that was skeleton argument that was on behalf of my learned friends. It's 4 paragraphs long. And really, the 4th paragraph dwells on the issue of fortification the whole way through, which is why Mr Justice Calver then talks about fortification in his judgment from paragraphs 121 to 125 onwards. But at present time, can I just show you Bank Mellet? I should also say to your lordship that, that actually Mr Bayard put 2 authorities before Mr Justice Calver, which are not before this court. They go to very much the same principles, but there were authorities in which your lordship gave judgment in both instances in the commercial court. And I can show you lordship the reference to that if necessary. Can I show you Bank Mellet, from which we've had a bit of a quote already? This is tab 3 of the bundle. For Lord Denning, Master of the Rolls, Lord Justice Donaldson and Lord Justice Slade. We've had its relatively short judgment, and I'll show you what I think you should be shown. It's pre-highlighted, but I'll take you to 1 or 2 other parts as well. So it starts at page 52. I don't think we need to trouble ourselves about the facts. Page 54 in Lord Denning's judgment, he says, second paragraph, it does raise an important point of Moravian injunctions I'd like to repeat what has been said on many occasions. When an ex parte application is made for a moreover injunction, it is of the first importance that the plaintiff should make a full and frank disclosure of all material facts. He ought to state the nature of the case's cause of action. Equally, in fairness, the plaintiff ought to disclose any defence which the defendant has indicated in correspondence or elsewhere. But obviously, that doesn't arise here. It is only if such information is put fairly before the court that a moreover injunction can properly be granted. So that's, as it were, the conditionality point that is picked up by Mr. G. Over the page, at page 90, Mr. Justice Donaldson, the second paragraph, this principle that no injunction obtained ex parte shall stand if it has been obtained in circumstances in which there was a breach of the duty to make the fullest and frankest disclosure is of great antiquity. Indeed, it's so well enshrined in the law, it's difficult to find authority for the proposition. We all know it, it's trite law, but happily we've been referred to a dictum of Lord Justice Warrington in the Crown and Kensington Income Tax Commissioners, ex parte de Polignac. He said it's perfectly well settled that a person who makes an ex parte application to the court, that is to say, in the absence of the person who will be affected by that which the court is asked to do, is under an obligation to the court to make the fullest possible disclosure of all material facts within his knowledge. And if he does not make that fullest possible disclosure, then he cannot obtain any advantage from the proceedings, and he will be deprived of any advantage he may have already obtained by means of the order which has thus wrongly been obtained by him. That is perfectly plain and requires no authority to justify it. And then can I go between the hole punches, if you've got it in paper? He referred us, I think that's Mr. Ratty, who was appearing, I think it's Mr. Ratty, who was making these submissions. As my lord had said, 2 or 3 cases relating to service out of the jurisdiction. He submits that on the basis of those decisions, the true rule is that non-disclosure, a failure to be full and frank in disclosure, is not a ground for discharging an injunction unless the non-disclosure was deliberate, and it wasn't in this case. Or if the non-disclosure, if corrected at the time when the application for relief is made, would have led to that relief being denied. And then that's rejected. It says it may be possible to extract that application of the general rule in the case of service out of the jurisdiction, but it has never been so applied in relation to injunctions. The distinction, I think, quite simply this. As Lord Justice Warrington said in that case, the court will be astute to ensure that a plaintiff who obtains an injunction without full disclosure or any ex parte order without full disclosure is deprived of any advantage he may have derived by that breach of duty. And then over the page, please, to the top of 92. For my part, I reject Mr. Ratty's submission. The rule requiring full disclosure seems to be one of the most fundamental importance, particularly in the context of the draconian remedy of the moreover injunction. And he goes on 2 sentences later, if access to such a weapon is obtained without the fullest and frankest disclosure, so that's the expression he's used before, I have no doubt at all that it should be revoked. And then, keeping it to principle, into the judgment of Lord Justice Slade, I agree. Mr. Strauss referred us to an Australian decision in Thomas Edison and Bullock. There, Mr. Justice Isaacs referred to the duty on any party seeking an ex parte interlocutory injunction in the following terms. There is a primary precept governing the administration of justice that no man is to be condemned unheard, and therefore, as a general rule, no order should be made to the prejudice of a party unless he has the opportunity of being heard in defence. And then I'll pick it up the last 2 lines, but when he does so, and the court is asked to disregard the usual requirement of hearing the other side, the party moving incurs a most serious responsibility. And then this wraps up at the end, to use the colloquial on page 93, the last 2 sentences of the major last paragraph. In these circumstances, I would agree with my lords in concluding that the learned judge, Mr. Justice Robert Goff, was entirely right in discharging the original injunction and in declining to renew that injunction. Can I show you Lordship's Block and Nicholson, which is next tab along, and is an interesting case for a number of different reasons. It was in the Court of Appeal, and this particularly centred around the non-disclosure of the fact that somebody was arrested and charged, but notably not convicted. It doesn't say whether he was convicted or otherwise, but just the non-reporting of having been arrested and charged. So we'll just pick it up at the beginning of Lord Justice Fox's revised judgment on page 59. This is an appeal by the plaintiffs, Mr. and Mrs. Block, from a decision of Mr Justice Tudor Price, whereby he discharged a moreover injunction which had previously been issued in the course of the proceedings. And it all related to a horse remarkably called Bold Lad out of Consensus for £30,000. And there was various property parts of the transaction, that's referred to in the third paragraph, and the injunction, which is at the bottom of the page, wasn't a freezing injunction, pure and simple. It was a more restricted version. It was applied for an injunction, then over the page, page 60, restraining the defendants from removing the proceeds of the filly out of the jurisdiction, the sale having taken place in England. I can then pick it up on the next page, which is 61. And at the top, in the quote, you can see the facts, relevant facts, were the first named plaintiff was on the 7th of August 1984, and I just paused there because he had sworn an affidavit about a month or so later, which you can see on page 60, third paragraph, 27th September 1984. So he had, by the time he did that, been arrested and charged in relation to obtaining money by deception. And then I can just pick up 2 or 3 paragraphs in the middle of the hole punches. As a matter of law, it's perfectly plain that it is a duty of a litigant who is seeking an ex parte injunction to make full disclosure to the court of any facts which would reasonably be regarded as relevant to the exercise of the court's discretion to grant such an injunction. The principle is in no way a technicality, it's of fundamental importance to the fair administration of justice. And then 3 paragraphs later, a matter of prime importance concerning the exercise of the court's discretion was to determine whether the implied undertaking in damages was an undertaking which the court could safely accept. This is my point of distinction between, before you get to anything like fortification, you've got to first of all know whether you can deal with it. In order to enable the court to weigh that question correctly, it was necessary that the court should have been told fully and frankly by Mr. Block that he had been arrested and that a charge of fraud had been made against him. It does not follow that if such information had been made available to it, the court would have declined to grant an injunction, although in my view it seems likely that the court would have adjourned the application to be heard inter partes. Be that as it may, what is of prime importance, the plain obligation of Mr. Block to have made a full explanation of his personal circumstances in relation to any matter which might be expected to affect the exercise of the court's discretion. And the fact that he'd been arrested and charged in August 1984 was a matter which, in my view, goes directly to the exercise of this discretion. The court should have been informed about it. And just to pause there wasn't any interplay, one way or the other, about whether or not this was hostilely denied, that there was an upcoming trial, the concept that in England somebody is innocent before they're proven guilty, and therefore there was nothing negative to be read into that. None of those concepts mattered. So can I pick it up at Lord Justice Balcomb's very short judgment? Of course, you will recall that he was one of the panel in Brinks, Matt and Elkham. Lord Justice Balcombe says, I agree that this appeal should be dismissed. I'd wish to endorse everything my Lord has said concerning the vital importance for applicants requesting ex parte injunctive to relief make full and frank disclosure to the court of all relevant matters, because the ability to meet the cross undertaking as to damages is clearly relevant. If subsequently it is discovered that such full and frank disclosure has not been made, an applicant is hardly in a position to complain if he loses the benefit of an injunction which was obtained without proper disclosure having been made. And Sir Laing Cumming-Bruce adds this. I agree. The notes to the orders then of RSC accurately set forth the proposition that on an application for ex parte injunction, the applicant is under a high duty to disclose all material facts, and that if it is shown that he fails to do so, the court is bound to discharge any ex parte injunction that has been granted without further inquiry into its merits. The duty is to disclose and fully disclose all material facts within the knowledge of the applicant. And if he does not make that fullest possible disclosure, then he cannot obtain any advantage from the proceedings and will be deprived of any advantage he may have already obtained. So said Lord Justice Warrington in the Income Tax Commissioner's case. So what are the material facts? Which is the duty to disclose? What's the test? This was considered in an Anton Pillar context by Mr Justice Brown Wilkinson in Thermax Limited and Shot, 1981. The test, which that learned judge, as he then was, applied, was affirmed in this court in 15th of October 85 in another case entitled International Bank and Trust Corporation against Perestrello. I refer to that decision because, as far as I'm aware, it's the first occasion on which the court has attempted to define or endorse the definition of the test of material facts. For the relevant purposes, Mr Justice Brown Wilkinson, he was, concluded a passage from his judgment with these words: I therefore think it is very important indeed that in making applications it should be in the forefront of everybody's mind that the court must be fully informed of all facts that are relevant to the weighing operation which the court has to make in deciding whether or not to grant the order. And Lord Justice Slade, in affirming that test, put the matter in this way: I would respectfully agree with these comments. I also think that the learned judge's reference to the weighing operation provides helpful guidance as what are the material facts which have to be disclosed on an ex parte application. If the facts are likely to be relevant to the weighing operation which the court has to make, then they are, in my opinion, material facts. And could I just show you very briefly Brinksmat and Elkham, which is the next tab along, and a well-known case, and oft applied. And if I pick it up at page 1, I'll use the big internal paging on the bottom right, page 70. And this is in the judgment of Lord Justice Rafe Gibson, at between F and G, and these well-known principles. So I'll take them quite quickly, and I'll be a little selective. So in considering whether there's been relevant non-disclosure and what consequence the court should attach to any failure to comply with the duty to make full and frank disclosure, the principles relevant to the issues in the appeal appear to me to include the following. The duty of the applicant is to make a full and fair disclosure of all the material facts. Secondly, the material facts are those which it is material for the judge to know in dealing with the application as made. Materiality is to be decided by the court and not by the assessment of the applicant or his legal advisors, and a reference to that Thermax case. 3, the applicant must make proper inquiries before making the application, the Bank Mellot case. 4, the extent of the inquiries which will be held to be proper and therefore necessary must depend on all the circumstances of the case, including the nature of the case which the applicant is making when he makes the application, the order for which the application is made, and the probable effect of the order on the defendant. And then C, the degree of legitimate urgency and the time available for the making of inquiries. May I just interpose a very quick point? I'm fascinated by the lack of clarity in the original skeleton argument put before Mr Justice Jacobs as to really when the preparation for the conduct of the application was being made. I'm going to show you those paragraphs so you can actually be aware of them.
Maybe fascinated, but what's your submission about it?
Well, the submission about it is that it really goes to it's part of the context of building up the very little amount of material that was said about wealth and the disclosure of Mr Salinas' wealth, the detail, as it were, contrasted with everything else. And one might think, well, they've had to rush around crazily to be able to get this all together. But when you look at the vast scope and scale of the skeleton argument, with about 8 or 9 different drop-in sections, huge amounts of law they refer to, huge amounts of analysis with the facts that they chose to parlay before Mr Justice Calver, they clearly must have taken a very long time to do it. And the window for showing you how long that time is actually within the body of the skeleton argument. And it looks like 6 weeks to me. But they very carefully, in an otherwise carefully set out chronology of what actually happened when, do not disclose when they started with the process. But it looks to me to be sometime after the 10th of June of that year, if not before. But it doesn't give that at all clearly, and it sits on privilege for not saying any more than they want to say. And so when you look at the vast scale of what's before the court, it is impossible not to conclude that there is a huge amount of preparation that has gone into it, which then makes the more shocking the disregard with which this whole chapter has been dealt with. That's the point of it, my lord. And in fact, having made that point, as long as your lordship has an opportunity to see it.
Perhaps put it in slightly less flowery language. They had an opportunity to put before the court the material which you say they ought to put before the court.
Your lordship puts it much better than I did. I will calm down. Could I take your lordship to, I was at point 4.5 If material non-disclosure is established, the court will be astute to ensure that a plaintiff who obtains an ex parte injunction without full disclosure is deprived of any advantage he may have derived by that breach of duty. At 6, whether the fact not disclosed is of sufficient materiality to justify or require immediate discharge of the order without examination of the merits depends on the importance of the fact to the issues which were to be decided by the judge on the application. 7, finally, it's not for every omission that the injunction will be automatically discharged. Then over the page to Lord Justice Balcombe's judgment at the top of what is 72 or 1358, at between C and D, it said this: the rule that an ex parte injunction will be discharged if it was obtained without full disclosure has a twofold purpose. It will deprive the wrongdoer of an advantage improperly obtained, see the tax case, but it also serves as a deterrent to ensure that persons who made ex parte applications realise that they have this duty of disclosure and of the consequences. And then can I pick it up between E and F when there's a reference to Bank Mellet and the Lloyds Bowmaker case, a recent decision of this court in which the authorities are fully reviewed. I make 2 comments on the exercise of this discretion. Sorry, I beg your pardon, I should tell you what he says before this. So let me read up between D and E. Nevertheless, this judge-made rule cannot be allowed itself to become an instrument of injustice. It is for this reason that there must be a discretion in the court to continue the injunction or to grant a fresh injunction in its place, notwithstanding that there may have been non-disclosure when the original ex parte injunction was obtained. And then the reference to the authorities. I make 2 comments on the exercise of the discretion, and this is an important part of the judgment in my respectful submission. Whilst having regard to the purpose of the rule, the discretion is one to be exercised sparingly. I would not wish to define or limit the circumstances in which it may be exercised. So, because it's so fundamental to the administration of justice, that's the point that's being addressed. It's not just being only put in to the weighing provisions as to whether it gets continued or not. This is something that has to be separated. I don't think I need to read on for the rest of the principles because that's not relevant to us at the moment. And I should draw to your attention that they actually maintained the injunction in that particular case, the last line of H. Then Lord Justice Slade, and I do draw your attention to this just over the page, 1359, again that reference that Kensington income tax case. I've had the advantage of reading and draft the judgments of Rafe Gibson and Lord Justice Balcombe. I respectfully agree with them, both in their analyses of the principles and the application of the facts of the case. The principle is, I think, a thoroughly healthy one. It serves the important purposes of encouraging persons who are making ex parte applications to the court diligently to observe their duty to make full disclosure of all material facts and to deter them from any failure to observe this duty, whether through deliberate lack of candour or innocent lack of care. And I think this is probably, I've only got 2 other cases to show to you, Lordships, then I'm finished with the authorities. Manor Electronics, which is again the next tab, 6. This is before Mr Justice Scott, as he was, travelling out on circuit, Leeds. I'm going to pick this up. I'll just show you maybe in the page 76 what the facts really amounted to. So this is a finance case, a non-disclosure of financial position again, so that's useful. Second paragraph between 20 and 25, the plaintiffs obtained ex parte orders restraining disposal of certain assets and for delivery up and discovery. They gave the usual cross-undertaking and damages, but failed to disclose that their financial situation was parlous. No evidence of their financial worth had been offered. And then they went back again and got another order, and this is between 25 and 30. On the basis of documents disclosed on the first order, they then sought and obtained an Anton Pillar order, again failing to disclose their financial position, and then held discharging the ex parte and refusing injunctive relief. So that was the outcome. And just summarising it on page 619 or page 77, at little 4, between lines 10 and 15, there had been material non-disclosure of the plaintiff's financial difficulties so that their cross-undertaking and damages was worthless. In the absence of reference in the evidence to a plaintiff's financial substance, the ex parte judge will assume that it is adequate to support the cross-undertaking. He depends upon the plaintiff making full disclosure. If there had been such material non-disclosure, then the court's practice is to discharge the ex parte orders without going into the merits. And then I'll pick it up, if I may, at big page 81, bottom right, left-hand corner, and at line 4. I now come to what I think is the most serious point in the case, namely whether there was proper disclosure by the plaintiffs to Sir Frederick Lawton when applying for the 2 ex parte orders. Ex parte orders for injunctions or anton-pillar orders are always accompanied by cross-undertakings in damages. These cross-undertakings are the protection that the practice of the courts provides for persons subjected to interlocutory orders in case the orders should turn out to have been wrongly granted. The evidence in support of ex parte applications often includes some reference to the financial worth of the applicant. The purpose is to demonstrate that the cross-undertakings in damages will be honoured if that should become necessary. I think, speaking for myself, that where there is no reference to the applicant's financial worth, the assumption will be that the applicant's financial substance is adequate for the purpose of the cross-undertaking that has to be given. And that's exactly what happened here with Mr Justice Jacobs, my lords. And the facts show out to be very different. Then I pick it up at line 40 of this page. Failure to put the accounts, line 38. Failure to put the accounts before the judge showing the financial position of the companies was, in my judgment, serious non-disclosure. The court is always very vulnerable when ex parte applications are made. The court has no alternative but to rely on the disclosure made by the applicant for the ex parte relief. There is no other source of information.
So sorry, where are you now?
I'm so sorry, my lord, because it's important. I'm on page 81, yes, bottom right, and line 40 of that. So, no, not at all. My apologies, going too fast. The court is always very vulnerable when ex parte applications are made. The court has no alternative but to rely on the disclosure made by the applicant for the ex parte relief. There's no other source of information. Full disclosure is assumed and is a condition on which ex parte relief is granted. This is my price of entrance to the cinema. If subsequently it becomes apparent that there's not been full disclosure, the practice of the courts is without more ado to discharge the ex parte orders. And then may I pick it up on the next page, which is page 82, and I'll start at line 2. I do not, however, regard that as an answer to the non-disclosure default. If there was inadequate disclosure, then the ex parte orders ought not to have been made and ought at once to be discharged. It is no answer to say that the orders improperly obtained have in fact been fruitful. The practice of the courts when material non-disclosure has attended the obtaining of the ex parte injunction is to discharge the order without going into the merits. That is a salutary and necessary rule of practice, and it is one that I propose to follow in the present case. The financial worth of a company applying for what I would call commercial injunctions, interfering with the manner in which the defendants carry on the commercial affairs, is always crucial. Otherwise, the cross-undertaking, if subsequently it transpires that the defendants are entitled to a remedy under it, beats the air. And then he discharges the orders. And that's what I need to show you. And I said there would be only one other after this, and that is the Staines and Walsh case, Mr Justice Laddie, and that's at tab 14. And I can pick this up at paragraph 35, which is on page 299. And he says, or rules, I've mentioned already that when a party applies for a freezing order, so page 299, my lord, for a freezing order, one of the requirements is that he must address the issue of the cross-undertaking in damages and his ability to service that cross-undertaking in damages. For that reason, save in the most exceptional cases, a claimant must put in a statement indicating his wealth, or at least indicating that he has sufficient adequately to cover the cross-undertaking. When a freezing order is made, it will continue to run until such time as it expires or is removed by order of the court. So long as it runs, the potential loss to the defendant will continue to mount. The cross-undertaking, he says at 36, in damages, of course, not only runs for the duration of the freezing order itself, but it can be brought into operation after the freezing order expires. In other words, it continues indefinitely. Certainly, so long as the freezing order is in force, it appears to me that there is a continuing obligation on the claimant not only to be willing to honour the cross-undertaking and damages, but to draw at least the defendant's attention to any material change for the worse in his financial position. Can I just pause there? When my Lord Justice Popplewell and I were discussing the interplay between, as it were, doing the court's best to price out the fortification in this particular context, what one always has to remember is that the defendant might be able to bring information about, as it were, the financial impact to the defendant or the respondent, but can't do anything about the information which has gone to the actual granting of the injunction, because the price of admission, the cross-undertaking in the first place, is being satisfied as to its bona fide nature and also as to its sufficiency. And so this is what that actually, that principle engages here, is that it's only the claimant applicant that best knows what the claimant applicant's position is. And so that applicant has the obligation to bring to the court relevant points. So if it was just down to facts going to liability or causation or damages, if they had some document that was going to make a dramatic difference, but that hadn't yet been disclosed, that of course would fall into that category. And ditto with any financial position, so that if it was known within the company that there was a drastic financial change of shape, or not even drastic, but material, then that is something that would have to be raised by that party. And it may be that the other party, the respondent, wouldn't seek to do anything about it, but the obligation starts as a continuing obligation by bringing that to the attention of the court, and obviously prior to that to the other party. So just to pick it up again, and not much more. At the halfway point of 36, if, for example, a claimant obtains a freezing order on the basis that he has £500,000 worth of assets, and those assets disappear in large part, in my view, it is inherent in the freezing order jurisdiction that he must disclose that change in position to the defendant, who can then, no doubt, after taking legal advice, either seek a voluntary removal or reduction in the freezing order, or go to court to seek such a removal or a reduction. And then the last paragraph I'll just show you is paragraph 46, which is on page 301. In my view, it would be wholly inappropriate to extend in any way the freezing order, which was made last year. Had there been before me an application to discharge that order even at this stage, I would have given it serious consideration. However, Ms Smith, on behalf of her client, made it clear her client doesn't intend to withdraw from court the money that he has paid in, etc. So that's what I show you. And I will now just tell you, Lordship, that the references that were made to the law very much would have and did cover this. And I just tell you, Lordship, that at the supplemental bundle at tab 16 at page 132, that's big page 132, which we looked at very briefly before, your Lordship can see that in little page 73 within the page itself, at line 19 and 25, Mr. Bayard brought to the attention of the learned judge two authorities, and he says, I know they'll be familiar, line 18, but could we just look at one of the authorities, which is Fundo Soberano, that's Mr. Justice Popplewell, at tab 22 of the authorities bundle, and he takes him to there, and then at line 24, you can see a quote from an earlier decision of the same judge in a case called Banca Turco Romana in paragraph 82. It's a duty owed to the court which exists in order to ensure the integrity of the court's process. The sanction available to the court to preserve that integrity is not only to deprive the applicant of any advantage gained by the order, but also to refuse to renew it. In that respect, it is penal. We'll come back to the authorities bundle just one more time, just to have a look at the Valbon case as to what we do next. So can I just move on to how those principles are worked out in practice? So one asks the sort of rhetorical question, what level of detail is required to discharge that burden, as to which I think the first two answers are. The level of detail will vary from case to case. However, it's possible to state some general principles. And as to the first principle, it will vary from case to case with commensurately cogent evidence, matching the scale of claim and the value of the claim and the working out of that claim. So it has to be cogent and proportional as an entry point. And it, of course, will very much depend on what you say your assets are. What's to be noted here is, when we look at the facts very quickly, is that the fact that the only facts that's recorded is, apart from a bald assertion, which is that he's one of the richest men in Mexico, that his wealth is defined by his holding in Grupo Electra. So if that's the way that you want to play it, then you have to tailor your disclosure to what you say your assets are. And there was literally nothing told in respect to what those assets are. One more reference to G. Sorry, I was wrong. I wasn't going to go back at this point, but I think I better had just show you in G. Both Malone Friend and I think, quote the same passage, but it's back to tab 29, and it's 9009. And that's at page 763 and 4. And so what author writes is this, 763-909, a matter which must be carefully considered is whether the applicant is likely to be good for any damages which he may be required to pay on the cross-undertaking as the damages. Such an undertaking is almost invariably required to be given on an application for an injunction or search order and will be dispensed with only in special circumstances, and he gives something to that, e.g. a claim by the Crown to enforce the law. In general, this matter should be expressly dealt with on the application, giving particulars of the applicant's solvency and worth. If nothing is said and an order is made, then the court will be proceeding on the basis that there is no reason to doubt that the person giving the cross-undertaking will be good for the damages. And then there's a quote of both the Block and Nicholson case and the Manor Electronics and Dixon case, both of which I've shown your lordship. So we can put that aside now. So at one end of the spectrum, an applicant says nothing about solvency or an asset position or an ability to enforce, and that's really our case. At the other, you can imagine a sworn statement from somebody empowered to make it, starting with the applicant themselves, or a senior officer if it's a corporate, or a bank manager, or a trusted accountant or financial advisor. And just to remind you, lordships, that the conglomerate that Mr. Salinas sits on top of includes a bank. So there he is borrowing money, but within the conglomerate is a bank, which is a financial arm of what is a retail, trading, banking and money lending operation. So typically, for example, what they do is they've got a whole customer range buying goods from their retail stores, and they, like a DCS agreement, they have sort of funding arrangements at the same time. So this man sits on top of a colossal amount of available means of describing wealth and, of course, of getting advice about all things financial, apart from the fact that he has an army of lawyers. So what is commonly done? Filed accounts, statements of cash at bank. You would think this is incredibly easy for somebody who's got a huge amount of wealth. If you really are a billionaire and you're a solvent billionaire, because there's plenty of people who appear in Forbes, but at the same time are disclosed, are made bankrupts. And Simon Hallaby was an example of that. He was worth $5 billion at the same time he's being made bankrupt by Couthing Bank for $57 million, and the revenue as a ghost. So the two things are not mutually inconsistent. So where's the evidence? It would be incredibly easy for somebody like this, with an army of people to assist him, to be able to do it if he wanted to. And if he wants to, it is to be, that's as it were, a gateway question. Because if he clearly didn't do it, he doesn't want to. If he doesn't want to, that is, I'm afraid, only consistent with hiding the position about his true financial.
Can I just understand how high you're putting this case?
Yeah.
There is some detail. It's said that he's one of the wealthiest individuals in Mexico with a net worth of several $billion.
Yep.
It explains that he's the founder of Grupo Salinas, conglomerate with interests in all sorts of things. It includes, although it's not limited to, Grupo Electra. It says he has a 30.47% holding in Electra, and one can see from the other, both paragraph 8 and what follows, that that's something that's going to be measured in, if he has that, billions of US dollars. Now, if you had no reason for saying that there's reason to doubt whether he's worth several $billion, would you still say that that was non-disclosure because the level of detail that was given was insufficient? Or are we realistically into the territory in which that is what has been said, the court will assume that what is said there is true, and it would have been material to disclose anything which cast doubt on whether that's true, and you have to point to the matters that cast doubt upon it?
Well, my lord, every case in this sense will turn its facts, so I don't know how one reduces it purely to the principles. But in this particular case, I think it's actually one principle. It's never going to be enough to say nothing about your wealth.
Well, he hasn't said nothing.
To provide no detail.
What I'm just pressing you on is, at the moment you're on submissions about what level of detail needs to be given. We've got at Mr. Salkida's first affidavit, tab 17, the supplementary bundle, paragraph 6 through to 8, essentially, the level of detail that is in fact given.
Very, very little detail. I mean, there's things that I'd like to say.
Pause. That's the level of detail which is in fact given. Now, if you didn't have any evidence to suggest that he was wrong to say that he had a net worth of several $billion US dollars,
and I'm simply...
Is it your case, because it seems to be, that at the ex parte stage, you need to have a level of detail which is greater than this, so that on that ground alone, irrespective of any evidence you might have been able to pull together, the freezing order ought to be set aside, because this is just insufficient detail, full stop.
Yes, I do.
Is that your case?
I do. I go as far as that. And that's because he only ties it to one asset class, and that's the shares in Electra. The shares in Electra is an incomplete story. He talks about a figure, if you just look at it, that you've taken me to it, which is tab 17, between paragraph 6.
No, but don't misunderstand me.
Sorry.
I'm not asking you whether there is reason to doubt whether this is sufficient to support the general statement that he is worth several $billion. If there is, we're into the material you say should have been drawn attention to. Well, at the moment, you seem to be confirming that you're saying what level of detail, the question you ask is what level of detail has to be given in the first tranche of evidence which is put forward in support of the freezing order. And I think you're saying this evidence, even if entirely sound and there's no reason to doubt any of it, is not sufficient detail. Are you saying that?
I am. As I'm reminded before I got to it, it's evidence of worth and not of solvency. So can I just start from one back? So I'm going to say two things. One is, as you're driving me to confirm, that I am going as far as to say a part of my submissions, that there is a submission which is this in alone is not enough, without any discoveries. The second is that there are obviously discoveries and there's a debate, and by the time it comes before Mr Justice Calver, there's plenty of material for Mr Justice Calver to want more information, and he's not provided with any more information. Okay, so there's a stubbornness about the claimants that they simply refuse to go further. Okay, but that's the second point. The first point, though, is, well, you've got to look at what's being said. So if you're the judge that receives this information, and if you're the advocate who draws your attention to this, you're told, my client is one of the wealthiest individuals in Mexico, all right? That's just, in my humble submission, a bold assertion. and he's worth several billion US dollars. That is a bald assertion, which he's not making himself, but somebody's making on his behalf. And he's got 30% of a company or a series of companies, and this is what the name of the companies are. And there's no information beyond that. And so you need to know, if you say, I've got a big treasure chest at home.
Well, there's a bit more information because there's information about what the share price was, at least at the time of the original. So as to give a ballpark,
but as soon
to the kind of scale of the company.
But he says it's owned directly and indirectly, owned and controlled. It's not, so what? And that changes shape quite drastically during the process of even the little information that we have. It starts off as 30%. Mr. Sklarov then found a document that showed it was only 10%.
You're not meeting the point I was
Sorry,
making to you.
I apologise.
I'm not on the further information you want to rely on in order to attack this. I just wanted you to clarify, and I think you have confirmed, if all this were true and there were no reason for doubting that he was worth billions, this won't do.
This won't do, because if you said to me, I'm a billionaire, I've got 30% of
I'm Mr. Gates. I'm Mr. Gates. I'm Mr. Gates.
Yes,
I'm seeking a freezing order, which may not cause much in the way of damage anyway. I say I'm a very rich man. Everybody knows I am.
Well,
that won't do.
My lord, we've been discussing Elon Musk was the example we came up with, but of course, I think that.
What's the answer? That won't do. Not enough level of detail.
That won't happen. That's the first starting point. But because Mr. Gates or Mr. Elon Musk would say, I'm well known and will give a bit more detail. And it will be enough because of the function and the prism of who he is.
What detail do they
the first
part to give?
Some description of their worth. And I own X% of Tesla. And this is currently listed in the New York Stock Exchange at a value of X. And I think that would be enough. But that's because Mr. Elon Musk is Mr. Elon Musk, or Mr. Gates, you can point to Microsoft and say exactly how many shares he owns, and that's publicly listed, and there's probably enough. Unquestionably, that would not be what he would do. Mr. Gates would never leave it like that, however little the injunction would be. I did a case with Nike on the other side. They didn't do that. They got an injunction. They put something short, sweet, and dramatic, and it completely answered the point. And here is a man who we now know, I appreciate that's the point of principle, is here is a man who isn't Bill Gates. He might like to think he is, and he isn't Elon Musk. And it's not enough to say, oh, I own 30% of shares which I own or control directly or indirectly, and in a set of companies I'm not telling you anything about, and where the very case is predicated upon the basis of already swooping value changes of the shareholding. And you don't know whether or not those shares are being held, as it were, directly or through a prism. If I say, I'm a customer of Berkshire Hathaway and I've got Apple shares, do you say, I've got lots of Apple shares? Or do you say, I've actually got an investment fund holding in Berkshire Hathaway? Now, in those cases, you're fine on both instances. But we're not in that territory here. We're in a very, very far removed territory. And there's precious little that's actually said. I'm sorry if that's just a detail point rather than, as it were, a gateway.
Well, you're asking us to lay down the law on the level of detail which is required at the outset, irrespective of what comes next. And therefore, I'm interested to explore what that may be. I have your submission.
Yeah, you have my submission, and I'm submitting that in this case, when you look at the seriousness of the undertaking and all the principles I've tried to draw to everybody's attention, and what sparse material was dealt with, and the fact that that is not descriptive of a direct linear link between shareholding and ownership, that is not enough. And a court that was engaged by it, and that is a court that has its attention drawn to it, is surely going to ask for more than that. And it's inconceivable that somebody who is wealthy like that, with nothing more to be said about their wealth, wouldn't actually go any further. One of the points we'll make is when you actually scratch the surface, it all falls apart. So, for example, it's clear that he's gone to BNP Paribas for a loan. But when you actually look at the portfolio that is actually in the bundle, you can see that there's precious little left in his position. I think he's got a surfeit of $10 million in excess of a gigantic series of loans. So he hasn't gone back to BNP Paribas. He's gone to the Astor defendants in order to be able to refinance. And when you actually look at what he's got, his shares are blocked. So you need, and knowing this is an example that back relates to your first question, which is when you know that there are different ways of holding shares and value, you need to know the mechanism by which the shares are said to describe the only detail that you give as to why you're a very, very wealthy man. And to you, the court's got to be three-dimensional to it, when you can see this information, and the party applying properly on trying to satisfy the cross-undertaking should be able to deal with that and hasn't dealt with it. And you should know material non-disclosure when you see it. And this is exactly it. It looks like this. And that's the reason why I'm so interested in you looking at the skeleton argument. When you look at the volume of detail of everything else, and this is dealt with in this sort of way, you have to ask yourself why that is the case. And when you're sitting in judgment on all of my points, not just one of my points, and you look at the fact that there has been this dogged refusal to actually try and meet what we're doing our best and the respondent shouldn't have to do, which is to try and suggest why somebody's statement that they're super wealthy without actually giving the court any detail whatsoever should be challenged, and that they don't deal with it. They just say it's enough. They play the identity game and they stick on the very point of this. It never gets more detailed in reality than that. And we just say that that is graphically describing non-disclosure, deliberate non-disclosure. And that's before you get to the active material that shows that the court should have concern about whether or not this is somebody whose word can be taken for the undertaking that they give.
It may not matter for your purposes, but one could question your proposition that it's non-disclosure. It's insufficient disclosure. I mean, one way of putting it is to look on in this unsworn affidavit, and I take your point that you made earlier. It is a rather curious document when we turn on to page 143 in the bundle, and we see two paragraphs with square brackets did not use, and apparently not even a jurat page, let alone an unsworn jurat page, but that may be just because it's been omitted from the bundle. But anyway,
I think this was affirmed, wasn't it?
Yeah, it was affirmed.
Yes. But anyway, leaving that aside, the way it's put here is in 154 and 155. With applicants willing to give unlimited cross-undertaking standard form, fine. Salinas personally liable under cross-undertakings is 155. Particularly high level of protection for respondents. Salinas, one of the wealthiest individuals in Mexico. And your submission is that is insufficient. It's not non-disclosure. I mean, you do say there's non-disclosure as well, but you say that is actually just insufficient.
I think I'm saying both, my lord, but your lordship's right.
But logically, the first point is insufficient.
It's insufficient, yeah. It's insufficient.
Yeah.
You don't get into the rest of it because you just don't get going. And therefore, the undertaking shouldn't be granted. And this is...
But that leads to this legal question, which is that a basis for setting aside the freezing order?
But it must be, because there is no satisfaction of the cross-undertaking. There cannot be any satisfaction. You haven't... It's material non-disclosure because you haven't drawn the attention to the points.
But that is the logic of your position, irrespective of whether there's any reason to doubt that it's true. The injunction should be discharged because there's just an insufficient level of detail. That is your the first way you put the case.
Yes.
Yeah.
Well, what happened in this case was, as I've said, a near to total silence. You have to look at the perfectly behaving applicant as a contradistinction to how they behave when you look at it retrospectively at this point in time, looking backwards.
Sorry to pursue the point.
Yeah.
I appreciate we're running out of time.
Sorry.
But we and therefore need to get on. But I must ask you this point, because I do not understand that this was the way the case was put before Mr Justice Calver, and maybe that's my fault, because it is one thing to say to Mr Justice Calver, look at the evidence that was before Mr Justice Jacobs. It was insufficient, and therefore he was wrong, and therefore the freezing order should be set aside. That is one legal proposition. It is quite a different legal proposition to say there was non-disclosure, and therefore the injunction was set aside. And as I understand it, the argument before Mr Justice Calver advanced by your clients was not of the first sort. It was not an argument Mr Justice Jacobs was wrong, because even on the face of the material before him, it was insufficient, and he should therefore not have granted the order. The argument was there was non-disclosure.
I believe your lordship's right. I believe your lordship is right. That it was put as one part of 5 aspects of material non-disclosure. But materially, the legal submissions that we've made, are making, arise out of, as it were, both situations, are either plain insufficiency or material non-disclosure. Amounts to the same, or the same consequence. I mean, this point is already known to the court, but I don't see this word in the authorities. But
I'm sorry.
I apologise.
And is this within your ground 3 ground of appeal, which is the core bundle at page 19? I mean, those address the judge's reasoning on the point that was argued in front of him.
Yeah.
Well, my lord, I believe that this effectively has been argued before the judge and has been summarised in ground 3.
You see, there's a conceptual difference, Mr. Davenport, because the first concept is Mr. Justice Jacobs was wrong simply on the face of the material before him.
Calvin?
No.
Mr.
Justice Jacobs.
Yep.
Because if the material was insufficient, he should never have granted the order in the first place.
But that's material non-disclosure.
No, it's not, because the whole point about material non-disclosure is the judge was right because there was material that was withheld from him, unbeknownst to him. Mm-hmm. There's a big conceptual difference.
We do not criticise Mr. Justice Jacobs. Mr. Justice...
Right, in which case you can't say the material was insufficient. Because as soon as you say it was insufficient, it necessarily follows that you're having to say Mr. Justice Jacobs should not have made the order on the basis of the material before him.
Well, the position we are trying to take is that because of material non-disclosure, that there was an insufficiency. The insufficiency was not drawn to his attention. So he just didn't go through the hoop. He just accepted it nem com. And that's what the authorities and the extract from Stephen G's book shows that as a matter of practice, the court will find itself in the position of assuming that it can be made good. That's what it amounts to. You assume that it's made good because somebody hasn't drawn your attention to the lack of it, either the insufficiency altogether, or alternatively the lack of detail.
All right, well, I must let you get on with your submissions.
So the clock's there, madam. Thank you very much indeed. So there's an asymmetry in the parties' positions, and because of that asymmetry, fair presentation is required for the reasons that we've shown your lordship. What went wrong in this case is that the material wasn't sufficient. We've looked at the oral submissions, we made references in the skeleton argument. All he was told was he's a wealthy Mexican businessman. And then he says, interestingly, I'll just give you the reference at the supplemental bundle, tab 11, page 116. I've got instructions that the first applicant, as my lord will have seen, is one of the richest men in Mexico. Well, that sort of flags the details, is that there's no evidence to it. It's just instructions that is the case. Mr. Justice Jacobs accepted at face value what he was told about wealth, to the point where even though assets were outside the jurisdiction, there wasn't even any fortification given at that point in time. Separate point, but nonetheless. There was, as to the evidence that supported that assertion, we've looked at Salcida 1 behind tab 17.
Salcida 1?
Salcida 1.
Deposes to what he deposes to on the basis of it being within his own knowledge, which is not wholly surprising. He's obviously a senior individual in Mr. Salinas' organisation.
Exactly, I accept that.
So he would have personal knowledge of what Mr. Salinas' wealth is.
I accept that.
Anyway, he says he does, and there's no reason to doubt.
Yeah, I can't go behind that.
No. So, reference to it being on instructions is neither here nor there. It is supported by what Mr. Salcida says.
All right. I won't press it.
No, don't tell me if I'm wrong about
it. No. Well, as a matter of fact, Mr. Robbins said it. So, any barrister that stands up and says on instructions, knows what they're engaging. It's not something casual. I would venture to suggest that Mr. Robbins could work out for himself that there was precious little that was actually in the bundle out of the 760 pages plus the 35-page affidavit that actually went to the question of his wealth. And so he's standing up and telling the court, I'm on instructions that he's a man of great wealth. And how much further does that go? How much more subcutaneous is it that Mr. Salcida, who knows him and is one of his employees, and under that position, has actually turned up and said that the boss is a wealthy man? It doesn't really add very much to it. Standing back, no documentary evidence, the thinnest of assertions, nothing whatsoever said about RBS, which was the actual counterparty, at that point already. And in respect,
you've confirmed that doesn't matter if he's good for the money.
I have confirmed that's the case. If he's good for the money.
What's the significance?
Well, the significance is then since we know that, why do they then start going on about the RBS value? If they can't see for themselves.
Well, they haven't in the evidence on this application.
They haven't in the evidence on this application. But they try and have it both ways, my lord. They don't put any evidence in. They don't meet the challenge.
If you accept that it wasn't material to put in evidence of RBS's wealth separately from sufficient and adequate evidence as to Mr. Salinas's is, then isn't that an end of it? So far as RBS's wealth is concerned.
It is, my lord, and I don't want you to indulge me in flourishes too much, but I would find it of interest that RBS would be suddenly asked to join the fray and deal with it in a pleading point as to what their value was.
We're not interested in what you're interested in. We're interested in what matters for this application.
Very well. Well, you've got my submissions on it. When it comes to the active interaction, Mr. Mr. Sklarov and Sklarov had declared Mr. Salinas showed the 10% of his shareholding with the purpose of the loan said to be refinancing. And maybe don't have to take you to that. And those shares were blocked with BNP. I would like to just show you that. Could you look at supplemental bundle? And we'll find page 187, which I think is tab 23. No, it is 27. Thank you very much. 27. Great to come from. So tab 27 is the BNP Paribas Wealth Management Report. And if you pick it up at page 179, which is about the third page in, the summary of that page, portfolio evolution is described, is he's cash negative 30 million, but so he's got a debt. But so we're in the second column along, looking from the top of the page. Market value USD as a certain date in 2020, and the value at 2021. This is what they've put in. Sorry, we've put that in. We've put that in. Yeah. So out of date, but you can see that at the relevant time, this is closer to the date of the loan. first loan, which was paid in 5 tranches going into 2023, that there's 30 million negative, 511 million in equities, producing what looks like a healthy balance sheet of 484, but 474 of that is actually in fact blocked. So you can see that at page 187. It's not, doesn't jump out the page, but I'll show it to you. So page 187, again, it's in landscape. And in the third entry down, you can see the shareholding Grupo Electra, and you pan across to its value, second column from last, $474 million odd. And if you go back far left again, you can see that next to the letters MXN is the initials BLO, and BLO stands for blocked. And we know that because that's the code that is described in 2 pages later in 189. And there's a disclaimer, and it says this portfolio holds blocked positions highlighted with BLO code. If you've agreed on a portfolio reconciliation procedure, you don't need that bit. So what we know is that there's the shares.
Excuse me, but what does that mean? What does it mean when it says it's a blocked position?
Well, blocked is something that can't be used without an agreement by the bank for any other purpose. So it's.
And how do we know that?
Well, there isn't any material that's before your lordship that can expressly do that, but that's common usage. Blocked, but when accounts are blocked or credit accounts are blocked, those sums are literally blocked.
But the BNP loan, which we were told in the evidence was the refinancing of which.
Well, we don't know if it's the refinancing of the BNP loan. We don't know that.
Right, but the size of the BNP loan. Does this tell us the size of the BNP loan?
No, the BNP loan appears to have been $50 million. There was one reference to a BNP loan of $50 million. But what this appears to show is
there won't be 474 million's worth of Electra shares which are blocked in the sense that they are blocked security for a $50 million loan, will they?
No, I don't think that relates to the $50 million loan.
Well, so what's the purpose of showing us that these are BLO?
Because it shows that in his portfolio, he doesn't have any real wealth. It's one piece of evidence showing that he has that the shares that he's identified here. This is 6.9 million Grupo Electra shares. Are blocked and therefore not free to be used. And if they're not free to be used, they're therefore not free to be counted in.
I'm sorry, how do we know that? Where is the evidence that tells us what this statement, it's a blocked position, means in real terms?
Well, my lord, Mr Sklarov said in his witness statement that they were blocked, and they didn't answer.
What does that mean? What is the practical effect of it?
I can't advance it any further forward, but can I just remind your lordship that this is the reason for why it's the disclosure obligation to remedy the asymmetry comes down to the applicant, and that the applicant should be dealing with these matters.
I'm sorry, I take the point that there is an informational asymmetry, undoubtedly so, but here you have a document that you are relying upon, and you are relying upon the statement that it's a blocked position. Why is it not? Why are you not able to put before the court evidence that says what this means in practical terms is as follows? You have a financial expert who will say, "I'm familiar with these kind of accounts. I'm familiar with statements about blocked positions, and it means the following."
No, I don't have that evidence to show you, lordship.
No, you don't.
No.
Right.
But what I'm showing is that A, there's an asymmetry, B, there's precious little information, C, when this is directly put in evidence, it's not answered, it's just left. And so that is of concern to a court when the issue about adequate disclosure or sufficiency of the position regarding the cross-undertaking is put before the court.
Can I ask you another point?
Of course.
In Mr. Salcida's first written statement, when he's describing the ownership of 30.47% of the share capital, he says that 30.47% is 67,544,000 shares. So this is a public company. It looks as though it's got a share of about 200 million shares. What you're showing us
is
at
10%.
page 187 is 6.9 million. So that's about a 3% shareholding in the company.
Of that BNP Paribas portfolio.
So you're showing us that whatever BLO means, if it means that those shares are blocked, that 3% of his shareholding in the company, or 3% of the share capital in the company is blocked, whether he has 10%, 30% or whatever.
Okay. Well, my lord, I need a lot of points to deal with before.
I know, but we're looking at this.
But I'm agreeing.
I had thought this was in support of a submission that all his Electra shares were blocked. I mean, as far as I can see, it doesn't show that at all, does it?
No, my lord, the point that we've made is that there's no evidence of liquidity that he has advanced, and we've put liquidity in issue. And so this is an example of where the liquidity issue breaks down, and it begs the question.
And just so I've got the timing, the date of this document is
2021.
April 2021. Is that before the Astor loan?
Yes.
So when it said it was to refinance the Astor loan, that's entirely consistent with this.
When it says, when the document says...
When the evidence that's been advanced by the claimants says that the Astor loan was to refinance the BNP loan, which I think it does, doesn't it?
Well, that's not evidence that they introduced. That's evidence that we show to challenge that it was 30%. So he says 30%. It doesn't tell us how the 30% is made up. And Mr. Sklarov has put in a witness statement which exhibits the fact that there's 10% of shares that are, in fact, owned, and that 10% is far removed from it. And within that document, it says refinance, and that's at tab 25. And it's small writing, but if you can find page 175, and the additional information says item 2, 10%.
Tab 25.
Tab 25.
Page.
Sorry, beg your pardon, 26. Apologise, my mistake. Page 175. Total percentage of shares owned by issuer 10%. I don't know if you can see that. Under E, additional information, 10%. And if you look above to question...
175, did you say?
Yes, my lord. 175.
Behind tab 26.
Behind tab 26.
Yeah.
And you have to look at landscape. And there's
total percentage
D
shares owned of issuer. 10%.
Yeah, 10%. And if you look above banking information, which is D, you see a little number 10, planned use of proceeds, corporate use / refinancing some existing loans, i.e. refinancing, repaying.
Yeah.
So, returning to my submissions, what should the claimants have explained? The claimants should have put objective evidence before the court showing Mr. Salinas' net asset position, explaining how many shares he owned and how, whether those shares were unencumbered, and the evidence is, including this, that Mr. Salinas generally borrows against his shares, not all of them, but against his shares. The tranches of drawdown on the loans are quite small by the end. The last payment is $10 million US. If you go back in the supplemental bundle to tab 23, you will see that at 167, albeit expressed in Mexican pesos, there is a schedule and the date schedule of the 5 drawdowns of the loan. And you can see that 2 are in 2021, and then there's a gap of about 5 months to February 2022, 4 months to June 2022, and even in September 23, he's then borrowing what is a relatively small amount of money, which is about $10 million US at the time. So this is somebody who is behaving in this fashion, needing these types of loans, has traded off his shares in the past, and these are all begging questions. So this is why he should have put objective evidence before the court.
So is your submission that because the fifth tranche involved borrowing the equivalent of 10 million US dollars, he could not have had liquid assets available to him by which he was able to meet an order of a court in that amount?
Well, it doesn't follow from one thing to the other, of course not.
Which is why I'm wondering why you're drawing our attention to this.
But I'm drawing your attention to it because it tells, the court doesn't just look at one thing in a linear bilateral relationship between one piece of information and the conclusion. Look at all the information and all the evidence, and the evidence suggests that this is somebody who's having to borrow $10 million, but he's turning around and trying...
might borrow $10 million. Doesn't tell you anything, does it?
Well, not in itself. When it's looked at, we submit, when it's looked at with the rest of the evidence that your lordships have, that it becomes interesting. It starts to build a picture of somebody who's reluctant to build a picture for themselves.
Right.
I mean, there's no corporate chart, there's no structure, and that type of material just hasn't been provided. Now, the identity game is being played by the claimants in respect of their submission. They're saying, well, this doesn't go to, some of these complaints are about Banco Azteca, they really don't go to Mr. Salinas. But Mr. Salinas is at the centre of absolutely everything. There's no room for that type of identity game to be played. And you can see from the material that we looked at, which is that he is offering the loan, that he is not advancing RBS, which I can tell you from the reply is being asserted as able to actually deal with the amount of the counterclaim itself. So they're not choosing to do it. So they're trying to show that Mr. Salinas is at the heart of everything. Mr. Salinas puts himself squarely in the middle of it. I've shown you paragraphs 6 and 7. And that is him asserting that he is providing on the subsequent hearings before Mr. Justice Jacobs, I think it was on the 7th of August, there were 2 subsequent hearings, 2 further ex parte hearings. The same formula of words is used, which is that they're providing plenty enough undertaking in order to give comfort for the joinder of the 5th and subsequently the 6th respondents to the litigation. And exactly the same words are used. And it's Mr. Salinas taking it upon himself to offer the undertaking in respect of him being the founder and the chairman of the conglomerate with the interest in many different businesses in Mexico, that he is an owner of the shares which are part of the overall conglomerate's profile. Yes, he says he's offering a particularly high level of protection to the respondents, and that's at tab 19, page 148, paragraph 74. You don't need to look it up, but it repeats itself. That's in supplemental bundle. The Yucatan Times article that we put in is...
Sorry, you say you don't need to look it up, but
oh, sorry, you were halfway through
the point that you're making. So,
right, okay.
I think I might have to...
Yeah,
tab 19.
So tab 19 of supplemental bundle, this is the 3rd affidavit of Mr. Sanchez, which at paragraph 74, which is page 148, says the applicants are willing to give an unlimited... the applicants, actually now, notice, are willing to give an unlimited cross-undertaking in damages in the standard form set out in the Commercial Court Guide. I don't know if that's...
They always did, didn't they?
Did they?
They both gave
it's the same wording as before.
But relying upon him, of course. And paragraph 74, I note that Mr Salinas will be personally liable under the cross undertaking, which provides a particularly high level of protection to the 6 respondents. Mr Salinas is one of the wealthiest individuals in Mexico. Yeah, it's the same word.
Thank you.
Could you, in the same bundle, turn up tab 29? This is an article out of the Yucatan Times article. It's talking about tax. And this is confirming that Grupo Electra, owned by Mr Pliego, owes 1.4 billion pesos in taxes. And there's journalistic commentary here. Of interest on page 198, at the top, Grupo Electra, which controls the commercial and financial branch of Grupo Salinas, including Banco Azteca and Electra stores, then filed a direct injunction through which it got a collegiate court to issue 9 observations. And then there's a reference to the amount of outstanding tax that is on Grupo Electra. And
so
that...
I'd understood, and this seems to confirm it, that what comes under Grupo Electra is the commercial and financial branch of the Salinas companies, but not, for example, Azteca TV and other. We see a number of other companies referred to in the Electra second quarter accounts.
Well, I think you might be right, but we've got no help from the claimants because they've not tried to clarify this at all.
That's what this suggests.
Well, that's what it suggests. Yeah, exactly. I agree.
Right.
Thank you. Everywhere there are references to these companies as being Salinas companies. He sits at the head. He's the founder of the group. He is really involved in every aspect of it. And of course, then that becomes more specific with regard to AT&T. And I would like to ask your lordships to look.
So can I just understand the numbers here?
Yeah.
The tax authority confirms that there's 1.4 billion initially, Mexican pesos. That's about $100 million, is it? Perhaps a bit less, something like that. We're working at roughly 18 to 1.
Yeah.
Got it.
I can make
the number you hit upon is at the end. It claims more than 38 billion pesos, which is somewhere up around 2 billion.
I think that we can get, yes, exactly.
Those are the numbers we're talking about.
We are, and if you turn with one hand to tab 33, you get more help because that's only one part of the tax that's owed. And behind tab 33 is another Yucatan Times article. Mexican official says Grupo Salinas owes the government 63 billion pesos, which is 3.8 billion US dollars. And then you've got...
That's not the tax authority, but it's a member of the government.
No, it helps you on the maths. It helps you a bit on the maths. We were looking at what the maths was. And so that's also another tax point, but it's showing $63 billion being 3.8 billion US dollars at that time. And this is 4 companies controlled by Mr. Salinas owe the government that sum of money. The head of the country's tax authority said the tax claims stem from 17 different court cases covering audits over 10 years. President Lopez...
This does come from the tax authority, yes?
Yeah, it does, SAT, I think. The morning press conference, Lopez Obrador, that's the president, said he hoped that Salinas will not keep using delay tactics so that my administration ends and the matter remains there pending. So there is some evidence. I said there was other evidence about not paying debts. This is part of that evidence chain. And over the page...
Well, sorry, this doesn't suggest that there were court orders for that amount, does it?
It doesn't. I don't have the information to give you, and they haven't given any information.
No, but what this suggests, both these documents suggest, is the tax authority are claiming that amount is owed in back taxes, and the evidence is that that's challenged.
Yeah, but the evidence is that it's happened over 10 years. So the idea that it's only, as it were, demands, rather than that it's actually got to a court case, because it is. There are court cases. There's 17 different court cases.
Yes.
So
current court cases
over
concerning audits which took place between 2008 and 2018.
Yeah, correct.
It doesn't suggest that the court cases go back to 2008.
No, it doesn't. But it suggests that there are court cases, and so it's not just demands which are left there. and whether or not, and it's not clear whether or not you can in Mexico, as it were, bring litigation to, as it were, get negative declarations in respect of tax liabilities. But it seems reasonable to conclude that there is a possibility which is not clarified by the claimants, and that's part of our complaint.
Yeah, I'm just trying to understand. I guess it's the tax authorities say that there is either 38 billion pesos or 63 billion pesos.
Yeah.
Quite different figures, really, aren't they? But they are.
Well, the different tax bills. I don't think they're trying to say. I don't think that article is saying that's all the taxes owed. The way it's been presented in the evidence was that overall there's $5 billion US dollars.
I think we'll get some help with the figures at 209 because it's 38 billion originally.
Yeah.
Inflation and fines brings it up to 53, and then there's some reference to an additional 10 billion pesos in tax liabilities.
Yes,
so that's how one gets to the 63.
Yeah, thank you.
But it's equally clear from this that Mr. Salinas' position is that these sums are not due.
Yeah, that's what he's saying. But that's the sort of thing we say.
One awaits the verdict in the Mexican courts.
Yeah, but what's happening is that the complaint is that he's forever using processes to delay any type of resolution, and that's just the way he acts.
It's not the suggestion we get this. You will have to show us where we get that.
Okay. All right. And can I just show you while I'm here? Tab 35. That's another tax matter. It's all against Salinas. I'm on the point of showing the connection to Mr. Salinas, not just the underlying problems. This is the link to government says Salinas company owes 3.8 billion US dollars in taxes.
This is a Bloomberg document.
This is a Bloomberg document. Thank you. Yeah. Then there's a reference to him saying it's an inflated tax bill. So I don't see anywhere where he says there's no tax owing. So it looks like the row is between what's the right amount of tax and what's the wrong amount of tax.
Well, certainly the previous one suggested his position was his companies had paid what was properly due.
Well,
the argument.
Well, the
advancing was that the claims were based on inflated bills.
Well, in any event, the point that we're trying to reach is that it isn't. You're not trying to reach settled conclusions in respect to this. It's a mistake to think that one had, and this is where the judge went wrong. And I have to deal with this.
All right, but what do we make? I mean, since you're relying on this document, what do we rely on the statement on page 221? Salinas, who has amassed a fortune of 14.9 billion US dollars.
Yeah. But
you say that we somehow ignore that, do we?
No, it's just an assertion. This, by the way.
Oh, that's an assertion of the rest of his evidence that you can rely on, is it?
My lord.
Oh, come on, Mr. Davenport. You can't have it both ways. Either you rely on the document as a whole, or you don't rely on it at all.
My lord, the position is that there was no evidence at all before the High Court judge that granted the orders. And Mr. Justice Calver was asked to look at them.
That comes back to the point that Mr. Justice Jacobs was wrong to make the order in the first place because the evidence was insufficient.
And the evidence was insufficient. And there was material non-disclosure at that point. And none of this is disclosed by the respondents to this appeal. This was all disclosed by our side. And it's pointing to a connection between Mr. Salinas and the various different companies. But the fact that there are assertions or statements that he's a rich person, which is something that he promulgates as a proposition, but the reality might be somewhat different, is that it's not something that can be used to bootstrap the position. But first of all, Mr. Justice Calver didn't...
If we take this at face value, what it says is he's worth 14.9 billion and he owes 3.8 billion in taxes. How does that support an allegation that he doesn't have sufficient wealth to meet the cross undertakings?
Probably it doesn't. Probably the document itself can't. I'm not showing you the document for that reason.
And why then would it be material to have drawn this to the judge's attention?
Well, my lord, it was before the judge, and
It wasn't. No, at the ex parte stage. If what this shows, if what this suggests is if he owes the tax that it's said he owes, he's got a fortune of more than $10 billion. Why would it have been material to draw this to Mr Justice Jacobs' attention?
But what is being said is it would have been it's material to draw all. He should have declared what he's worth, and he didn't. This isn't showing him what he's worth, and it couldn't be relied upon.
So your submission would be the same if this document didn't exist, because it all comes back to the fundamental proposition which you're advancing, which is the evidence was insufficient.
Which it was.
So this in fact is entirely neutral on your submission, because your submission would remain the same if the document never existed.
In that respect, yes, because it is just journalism. So the journalism is only showing some links. That's why I'm showing it to you, not because
so the journalism is worthless. So you can't
for that point,
and therefore, where does any of this take us?
Well, I'm happy just to leave this document alone if your lordship takes that. I'm trying to show you to the link between Mr. Salinas and, as it were, the tax demand, and that Mr. Salinas has linked himself by his proposal that he and alone gives the cross undertaking, which will do for the claimants. And it's all part of the same story, which is that Mr. Salinas, without doubt, is at the centre of all matters. And in the AT&T material, which I'm determined to take your lordships to, that is what became very apparent. And that is what Mr. Justice Calver was informed of. Mr. Bayard informed him of the consequences of the movement of the resources that these companies had. Grupo Salinas Telecom 1 and 2, and that's the reason why the AT&T material is highly relevant. So now I apprehend that your lordships are familiar with this material.
No, I'm not.
Oh, right, okay.
It's in an unagreed bundle.
No, not all of it is. You see, that's the point. Is that there's 3 documents which are in the which is in the agreed bundle. So in the supplemental bundle. So can we have a look at this first?
Well, I'm speaking for myself. I'm not familiar with this. So do
okay.
Take me to it.
Okay, we will. Thank you. So can you pick the supplemental bundle up and start at tab 36? And at tab 36, this, I'll tell you what this is going to show us. This is referring to the judgment of $20 million having been entered, that there's a history of refusal to pay judgments, that there is a boasting of the non-payment of judgments by Mr. Salinas, and that there are other tax debts that SAT, the Mexican Tax Authority, claims to be owed by Grupo, and references to Mr. Salinas boasting, I won't pay a radish's worth of those debts, and the Grupo insisting on putting adversaries through enforcement process, so not willing to pay up. So this goes to the point of not just a sufficiency, but not willing to pay the any consequences of the cross undertaking. So here we go. This is the decision and the order on motion at page 228, and it's actually, this decision rejects an attempt by AT&T to do what's called post security in the form of a bond. That's the first main paragraph, in the amount of $7 million to secure damages at this.
Can we just look at it?
Yeah, of course. So in motion 02, defendants, AT&T Mobility Holdings. So I should tell you that what happened was, and I don't know the detail of it, but Grupo Salinas was the plaintiff and sued AT&T, who counterclaimed. And AT&T's counterclaim succeeded to the extent, when you look at the whole picture, that what Grupo Salinas 1 and 2 are going to do is abandon, they sack their counsel, and they end up, as it were, parting company, Paul Weiser & Co. part company at the time.
Can we just look at it and then
find this a bit.
Rather than keeping telling us what it says or other things say.
Okay.
Can we just look at it?
Yeah. In motion 02, defendants AT&T Mobility Holdings and new singular wireless services move pursuant to the court's inherent authority for an order directing Grupo Salinas Telecom 1 and 2 to post security in the form of a bond in the amount of $7 million to secure damages AT&T seeks in its counterclaims in this action. And then there's some comparison with another case called Baltic Street Partners and Stern and Lag, that case. And this judge says it's not as serious as that case, and she ends up by refusing the order. But at the bottom of 229, here we have Grupo refusing to pay the judgment in another case before this court with the same parties, and a history of refusing to pay judgments and making public statements espousing its pride for failing to pay its judgments. And then makes cross-reference to an article wherein Grupo's chairman, and that's obviously Mr Salinas, declared he won't pay even a radish's worth after a Grupo affiliate was found to owe the SAT over $200 million in tax liability. And then about 4 lines, so that does show that there was a court case. And then 5 lines later, after a bench trial, this court rendered a judgment for over $20 million against Grupo. Grupo has appealed the trial decision. Grupo insists on putting its adversaries through the judgment enforcement process. And then next line, Grupo has the option of paying a bond or insisting that AT&T engage in the judgment enforcement process. To be clear, this court does not condone Grupo's failure to pay the judgment in the AT&T action. However, it is premature to secure Grupo's payment of AT&T's damages in this action where the parties have just completed document production. Okay. And then if I can take you to another document which was before His Lordship, and this is at tab 39. And pick it up at page 40, and the same judge seems to be docketed, or anyway appears consistently. Second, so the first paragraph, plaintiff moves by order to show cause for a turnover order and appointment of a receiver. And second paragraph, AT&T holds a November judgment against Grupo Salinas Telecom and Grupo Salinas Telecom 2 for over $20 million following a trial before this court for breach of the party's stock purchase agreement. On the September the 19th, 2023, the court found that Grupo had breached its agreement to indemnify AT&T for all taxes and damages relating to any taxes imposed on the Lusacal entities relating to or attributable to a time period prior to AT&T's acquisition, and any breach of Grupo's tax-related representation and warranties. The parties agreed to New York as the forum for disputes. Over the page, AT&T seeks an order directing Grupo to turn over all of Grupo's disclosed and undisclosed cash on hand directly to AT&T. Secondly, Grupo's shares of Grupo Electra to a receiver. And thirdly, Grupo's shares of Servicios T-Play to a receiver. AT&T requests appointment of Robert Seiden as a receiver. The motion was granted for the reasons stated on the record as to the first and second request. The court now grants the motion in its entirety with this decision, which supplements the record. And AT&T is satisfied, A, which provides property in the possession of judgment debtor, so they've got property, and then underneath that, AT&T has established that Grupo has custody or control over cash and other assets sufficient to satisfy the judgment. Next line, indeed, Grupo does not challenge AT&T's request for turnover of Grupo's $147,000 cash and 150,000 shares of Electra that Grupo valued at $10.45 million, that they themselves valued at. Rather, Grupo focuses on STP, a private Mexican company in which Grupo owns shares worth over $800 million, which far exceeds the amount of the judgments. However, over the page, based on Grupo's responses to AT&T's information subpoenas, Grupo's cash and Electra shares are insufficient to satisfy the judgment. So she says, according to this case, differs from another case, a case relied upon by Grupo for the proposition that turnover is disproportionate, and thus AT&T's motion should be denied. Their turnover of membership interest was not necessary, as CIMC had sufficient cash and liquid assets. And then at the next paragraph break, AT&T has satisfied the requirements for appointment of a receiver under that law, and then she just debates that. And then if we turn over the page at the second paragraph, the second factor, so the factors in play, I suppose I should show you the first paragraph. For appointment of a receiver here, the court must consider the alternative remedies available to the creditor. Secondly, degree to which receivership will increase the likelihood of satisfaction of the judgment. And 3, risk of fraud if a receiver is not appointed. She goes on and says, AT&T has requested turnover of lesser valued assets, cash and Electra shares, which according to Grupo are valued at $10.6 million. Given the limited information Grupo has provided to AT&T, the court is satisfied that AT&T has no alternative to turnover of STP. The second factor, that's the receivership will increase the likelihood of satisfaction, is also satisfied. Appointment of a receiver is especially appropriate when the property interest involved is intangible, lacks a ready market, and presents nothing that a sheriff can work with at an auction. A receiver can work with Grupo's shares in STP, its private Mexican subsidiary, to satisfy the judgment. Over the page, the court rejects Grupo's arguments that the receiver will not increase the likelihood of satisfaction of the judgment because the powers granted the receiver violate Mexican law. So that point was taken. And then I think I can skip the second paragraph. It is third paragraph. AT&T also satisfies the third factor, that's the fraud factor, by offering special considerations that merit appointment of a receiver. Grupo has the assets to satisfy the judgment, but refuses to do so. Again, the court rendered its decision on September 19, 2023. On September 22, 2023, so that's 3 days later, Grupo transferred its shares in Electra from its account at Vector, a brokerage based in Florida, to Banco Azteca, a Grupo affiliate based in Mexico. Moreover, on September 27, 2023, so 4 days again later, Grupo moved over $5 million from bank accounts at Intercam Bank in Mexico to a Canadian entity called Security International Investments. On October 16, 2023, Grupo liquidated $10.12 million in Security International Investments shares and made a capital contribution to STP. Grupo failed to disclose these bank accounts or transfers in its discovery responses. Grupo does not deny that it took these actions to evade the judgment. Rather, Grupo explains that there was no restriction preventing it from doing so. Such suspicious transactions are enough to establish a risk of fraud and satisfy the third factor. Appointment of a receiver is necessary to satisfy the judgment. Finally, the court rejects Grupo's attack on the language of the order appointing the receiver. Grupo misstates the purpose of the appointment of the receiver, which is needed to monetize Grupo's non-liquid interests, not run a Mexican company. For example, as raised during the argument, the receiver could use the shares as collateral for a loan. Whatever the receiver's course of action, the receiver must have the powers necessary to accomplish the job to satisfy the judgment. The court has directed AT&T to have the proposed receiver review the proposed order, and the court will consider Grupo's objections, if any, to any changes that Sidon, that's the receiver, suggests. And then the third document that was before the judge is at tab 44. It's a shorter document. Another decision and order on motion. And this is, note the date, 7/12/024. I better get that right. I think that is the 12th of July, American expression of the date. Paul Weiss moves pursuant to...
So it's my fault. Did you say tab 44?
I did, my lord, yes, I hope so. I beg your pardon?
Yep.
I'm told it's the 8th of August. I think at the top, the received document is the 8th of August.
Yes, that's
the
what the
motion date. Yeah,
263.
Oh. I'm looking at the motion date.
Motion.
Yeah, exactly. The motion date's that date. And yeah, thank you. Right. Paul Weiss moves, pursuant to those rules of professional conduct, to be relieved as counsel for defendants Grupo Salinas Telecom. And 2, Grupo has terminated PW, that's Paul Weiss, and consented to PW's withdrawal. And Grupo has determined to pursue a course of action with which PW has a fundamental disagreement. Since PW was terminated, it need not establish good and sufficient cause, states the law. Second, 3 lines later. Here, Grupo terminated PW to avoid payment of a $20 million judgment. There's been no breakdown in communication. Indeed, PW continues to represent Gruppo in an action in the US in the Southern District of New York. Further, PW is identified for the purpose of notification in the agreement at issue in this case, and there's been no effort to modify that provision. Gruppo's intention in terminating PW to avoid AT&T's $20 million judgment is clear from its actions. Gruppo started to remove its assets from the United States 3 days after the court's judgment. Gruppo has not provided required information. Now Gruppo terminates its counsel, PW. And she says, under these unusual circumstances, as discussed on the record, and on consent, PW should continue to receive service of documents in this case. And
forward decision postdates Mr Justice Jacobs' order.
No, my lord,
Postdates it.
Postdates, yeah.
So it couldn't have been disclosed to him because it hadn't been made.
Well, it could have been voluntarily disclosed. Part of what we're saying
is the date of his order.
Oh no, this could.
The decision hadn't been made, therefore it couldn't have been disclosed.
No, I'm just saying.
I assume your point is it should have been disclosed prior to the subsequent.
Of course, but the whole history of it should have been disclosed, of what they were going up to, because it's relevant to the undertaking and whether or not these people are ever going to prepare to actually pay up on their undertaking in that eventuality.
These were documents which were exhibited, were they, to...
These are the documents
Mr. Sarkady's
these are the ones that came. These are the ones that came in by email.
These are the night before email.
The night before email.
These are the night before email. Yeah. Okay, so that's not. They're not referred to in paragraph 72 of Sarkady, and they're not dealt with in any responsive evidence.
They're not dealt with any responsive evidence. There is some dealing with some aspects of the complaint. There is a very useful exercise to be done by looking just at 2 paragraphs comparatively. My point to show you that, maybe I'll get to the end of this, and then I'll just show you the two relevant paragraphs, is that most of what is alleged to have happened is agreed as having happened. Its relevance isn't conceded, but it's agreed as having happened. And so that's material non-disclosure. They're just simply saying, well, okay, it may have happened, but it's not material to have been disclosed.
All right. I'm sorry, I'm now confused, because you very correctly pointed out these are not in the unagreed bundle, these are in the agreed supplemental bundle. Okay. But you've also confirmed that these are indeed the 3 decisions that came in by email at 5:49 p.m. The evening before the hearing.
Yes.
As to which the respondent's skeleton argument, drafted by Mr. Robbins, says that your clients didn't apply for permission to adduce late evidence or for an adjournment, and says in those circumstances the judge was right not to place any reliance on these materials, and so on and so forth.
That's what he says, yes, indeed, after the event. So he's not saying, and we objected. Going back to the objection point. I'm agreeing with your lordship reading that. I don't know what your lordship
I'm unclear. The reason I'm asking the question is I'm unclear what the position is, because as I understand it, you don't dispute that the documents came in late. I don't think you can dispute.
I'm averring it. Yeah, of course.
Right.
They came in late. Well, when we say late...
So, given that they came in late, as you accept,
yeah,
does it not follow that it was incumbent upon your side to seek permission to rely upon the late documents?
Well, only if it had to have the status of material that was before the court in a formal sense. But it appears, when we look at the transcript, that there was no formal complaint, and the court simply looked at the documents. There was no de bene esse reference that I can see that the documents were looked at. So the documents just went in. There wasn't an issue between the parties. What appears to have been the case is that in the skeleton for today's hearing, Mr. Robbins, who is not here, drafted the argument to say that in the way that your lordship's read out. I don't need to repeat or summarise.
But it's implicit in that submission that it was incumbent upon him to object, whereas what I'm putting to you for your response, and maybe it's you simply say I'm wrong, is that it was incumbent upon you to apply.
My lord, I'm trying to duck both of those questions.
Well, that's very candid, but I'm not sure it helps.
And I'm trying to say it was in evidence. That, and in moving litigation along, you don't always have to have set piece applications because things happen, and particularly in fast moving.
And then what happens is the Court of Appeal is left in a mess.
Well, okay, but don't blame me because I wasn't there.
No, well, neither of the advocates before us are involved.
Yeah.
So there we go.
Yeah.
All right. Well, I think that's probably as far as we can take matters at this stage, and we will break there and resume at 2 p.m. How are you doing time-wise?
Well, I am trying to really move as quickly as I can, but cover the material. I will obviously, over the short adjournment, work out a way of covering the material as quickly as I conceivably can. If I was to try and guillotine myself to, should we say, 20 to 30 minutes, can I immediately declare that my learned friend quite reasonably asked me yesterday by email whether we should split the time between us of the 4.5-hour hearing. And I said, well, it rather depends on what the Court of Appeal want to do. But of course, as between us, that's the arrangement that was only fair. So I fully accept that I'm already over my allotted time period. So I just want to be able to deal with the points as best as I possibly can. I'll try and give your lordship some reading list, as it were, and ask your lordships to contemplate that. And I'll try and get through the material as quick as I can.
All right. 2 o'clock.